Hello, hello. My name is Mike Zajko. I'm a PhD candidate in the Department of Sociology here at the University of Alberta. I'm interested in studying the roles and responsibilities of telecom companies and internet service providers. So two of these roles are particularly important today, and that is these companies' role in disclosing personal private information to governments or other third parties. And the second role, which sometimes conflicts, is their role as privacy guardians, guardians of our personal information. And our relationship with these companies has really become more intimate over the years. And that's why it's very important right now that we pay very close attention to what this relationship entails, what sorts of information about us and from us is being collected, and then also who that information is being shared with, under what circumstances. So there's two big lessons that I think are relevant to this conversation that have come out of some of the Edward Snowden disclosures in the past year. One of those is that a lot of these bulk surveillance collection efforts wouldn't be possible without the cooperation and assistance of some of these telecom companies, these service providers. Now, the other lesson I think that is important is the fact that governments, government in Canada and the UK and in the US seem to have a slightly different idea of what counts as privacy or acceptable behavior than some of the general population, and in particular the internet community. So the reason why I think the first point is important is because these companies that I'm interested in have a considerable amount of leeway in deciding how far they want to go in cooperating with things like government requests. We know from one of the documents released through Edward Snowden's disclosures that after 9/11, the NSA approached several telecom companies and asked for their assistance. And the level of cooperation that they got varied. Some companies opened the door wide, some of them opened it a crack, and at least one of them said that they weren't really comfortable in participating because of liability concerns. Now in Canada, we had a similar or related discussion around lawful access legislation back in 2012. And this specifically addressed the voluntary nature of a lot of the disclosures being made by these service providers to governments. And the government wanted to essentially standardize compliance with this regime so that right now, if an internet service provider receives a request from a police officer that doesn't have a court order or a warrant of any kind, then they have a lot of leeway in deciding whether or not to comply. And generally, when it comes to disclosing basic subscriber information, as they call it, they do comply. But in some cases they don't, and they demand a warrant or they don't respond, and the government wanted to make sure that a lot of that voluntariness was taken out of that information sharing. So my second point relating to the Edward Snowden disclosures has to do with the privacy status of a lot of this information and what it seems might be legal and why this might be a concern, or I would argue should be a concern to all of us. Perhaps the most significant disclosure to date involving Canada had to do with a program to track people as they moved through Canadian airports, hotels, coffee shops, accessing Wi-Fi in different places. And the idea behind this seemed to be that the government, and specifically CSEC, our Signals Intelligence Agency, wanted to be able to look at this picture of masses of people going about their daily lives and all the digital traces that entailed, and be able to zoom in on some of these digital traces and figure out who identifiable people were at a given time. And they seem to have had the assistance of a telecom company in doing this, but we don't know who. Now the government tells us that this is legal, and that might very well be the case. This might be legal because what we're talking about fundamentally here is metadata, and that's a word that's come up a lot in the last year. And it seems that governments and their intelligence agencies in Canada and the US are of the opinion that generally metadata is not protected, certainly not at the level of communications like emails and phone calls. But what metadata can entail, first of all, are things like IP address, but also location information. So it might be legal to monitor the location of all Canadians in real time, provided perhaps certain safeguards are in place. But we don't know what those are, because these are secret agencies conducting secret programs with, by and large, secret interpretations of privacy law. And courts have also been looking at this question of metadata in a number of other contexts. So there was recently a case in Ontario that involved an internet service provider's responsibility to disclose the basic subscriber information of its customers to a film company that wanted to sue some of them for copyright infringement. And the court really had to consider what adequate privacy safeguards could be in place here. And the internet service provider also had to consider what its role and responsibility was to its subscribers, how far it could or should go in protecting this private information in this circumstance. In another case currently before the Supreme Court relating to child pornography, the court is also grappling with this idea of IP addresses. These are addresses assigned by internet service providers to their subscribers, and determining when the disclosure of an IP address to police constitutes a search, and just what you can do with that one piece of information, an IP address, given all the other digital traces out there and possibility of learning things about people through their internet use. So finally, we have Bell Canada, which recently changed their privacy policy, saying that they were going to monitor all sorts of behaviors about their mobile subscribers, web browsing, location, in order to better tailor personalized ads for them. So we really have to ask ourselves whether this is the sort of relationship that we want with these companies, and whether we are comfortable with these kinds of information being collected and who they might be shared with. That's why I think it's really important to have a debate about these questions, and the only way we can do that is with greater transparency and information about exactly what the nature of these relationships are, these legal interpretations. And that's why I really support the efforts of the Citizen Lab at the University of Toronto to have greater transparency and disclosures around these topics. Thank you very much.